Hi, my name's Malcolm Shivens. I'm the President of the Guardianship Tribunal of New South Wales. I'm a barrister and solicitor. I've been at the Tribunal here in New South Wales for about 3 years, and I've worked in guardianship law generally for just on 10 years. Enduring guardianship is a system where all of us can choose to appoint a person, someone who's close to us, to make decisions for us when we might lack the capacity to make those decisions for ourselves, either temporarily or permanently. It's completed by way of a document with legal requirements where you have a conversation with a person that you choose to be your enduring guardian. You specify the powers that you wish to give that person, and it mainly involves lifestyle decisions. So it might allow for that person, when you're unable, to make decisions about your health treatment, where you might live, who you might have access to. It's all up to you, when you're appointing enduring guardian, what powers they should have. It's important that all of us consider appointing an enduring guardian, because we can never predict what life holds. Any of us could suffer an injury which could temporarily leave us unable to make important decisions about lifestyle, about medical treatment, or about where we should reside, for example. Appointing enduring guardian gives peace of mind and effectively appoints somebody to give you a voice when you're not able to apply that voice for yourself because you're currently incapacitated. So appointing an enduring guardian means that somebody you trust, somebody who knows your preferences and how you might make the decision that's confronting your circumstances at any point in time, can make those decisions on your behalf when you're not able. Probably the most important thing, first of all, is to discuss with the person or persons you're thinking of appointing what you're thinking of doing, see how they feel about taking on that role, and make sure that if they're content to take on that role, they understand the powers that you would be giving them and how you'd wish for them to carry those wishes out. After that, however, so long as you're over 18 years of age and you're able to understand the nature and the effect of the document you would need to sign to appoint an enduring guardian, then it's a matter of either seeking legal advice or obtaining the relevant documents to complete the enduring guardianship form yourself. Yes, there are special requirements when you're appointing an enduring guardian. The words and the form, if you like, that needs to be used is prescribed by law. So that form can either be obtained from the Guardianship Tribunal, from our website, or obviously if you're seeking legal advice, your solicitor will be able to assist with that form. It's important, as I've stated, that you decide what powers you wish to give to your enduring guardian, and that should be specified in the document. There's particular rules also as to how the document can be witnessed. So you must sign the document. The person or persons you are choosing as your enduring guardians must also sign, and it's important that it has an eligible witness. So some examples of the eligible witness must be an Australian legal practitioner, or alternatively an approved officer of the New South Wales Trustee and Guardian. When choosing your enduring guardian, the most important thing is to choose somebody that you trust. That person, if the document needs to be used, will have the power to make decisions about your medical treatment, perhaps where you might live, either permanently or temporarily, and who you might live with, for example. So very personal decisions. So it's important it's somebody that you trust and somebody who knows your preferences, who can make a decision as closely aligned to the decision you might have made, were you able to make the decision. So that's very important. It's also important that it's a person who's contactable in whatever circumstances could arise. So you might want to take geography into account as to where they reside. Not with technology these days that's necessarily a barrier, but it's important that it's a person who can be contacted in the circumstances that may be urgent. And probably the final issue you'd need to take into account is how well that person gets on with your other close friends and family. When a situation arises, it's important that loved ones are involved in the decision making, and it needs to be a person who will engage in that conversation with those who care for you. Yes, you can appoint more than one enduring guardian, and there's several ways in which you can do that. Firstly, you can appoint your enduring guardians jointly, so they will need to come to a consensus on any decisions that need to be made. Secondly, you can appoint more than one person jointly and severally. So that means that one person alone can make decisions if the other is not available, for example. And thirdly, you can give different functions or powers to different persons as your enduring guardian. So you might appoint one person with the power to make decisions as to your medical treatment, and you might appoint a different enduring guardian to make decisions as to your accommodation and where you reside.